And now we go to Brazil, where the country's fifth regional court is currently analyzing a 1992 lawsuit settled by ranchers willing to evict Xucuru Indigenous people from their village. Our correspondent Brian Meyer has all the details. Let's see.
A 1992 lawsuit launched by politically connected ranchers has made its way up to Brazil's fifth regional court, despite being based on a clause in the invalid 1934 constitution. If approved, 100 indigenous families living in a village in the Xucuru Indigenous Reserve in Pernambuco will be forcibly evicted from their land.
The history of this country doesn't make sense without us, because we are the first inhabitant of this land called Brazil. Who doesn't know this? Therefore, it's unacceptable to see some people who occupy important spaces of power and decision-making try to rule on a case simply based on written words. We have to understand that we are in another moment in this nation's history.
Human rights observers are especially concerned about this case, since its core argument is based on the concept of time stamping, which cancels all indigenous reserves created after the Constitution was ratified. After the Supreme Court ruled the agro-lobby's time-stamping law unconstitutional this year, right-wing members of Congress immediately sanctioned a similar law. If the Xukuru are evicted from their land, it could set a dangerous precedent with national repercussions.
They don't think about a tree or the diversity of wild animals and birds. They see the land as an object. We're different. We love birds, the animals and the trees. We respect it, and we try to preserve and protect it as much as we can.
This week, Brazil's fifth regional court announced yet another delay in its ruling on the Xukuru eviction case. Brian Mir, teleSUR, Pesqueira, Pernambuco.